and welcome to a fresh episode of Legal Wrangle on corporate laws. Today, we have 6 interesting cases like shoe cartel and airlines cartel case, which once again shows the grounding trend of reversal of decisions of Competition Commission by the COMPAT. Then, an IPR case where Ericsson found guilty by the Delhi High Court for suppressing material facts in a patent infringement suit. A banking law case on interpretation of the term Encumbrance under the SARFAESI Act and much more. Let us begin with recent judgment of the Competition Appellate Tribunal relating to identical or near identical quotations submitted by bidders in a tender. The dispute before the COMPAT was how weightage to be given to such similarity of bids to conclusively establish presence of cartel. Shalu brings the facts.
The tender was floated by the Director General Supply and Demand for procurement of jungle boot, which was required to be manufactured in a specified manner. In 2011, when tender was floated, DGS&D found identical bids being submitted by the appellants, and therefore reference was made to the Competition Commission with the allegation that the appellants had indulged in bid rigging for determination of price and quantity of the product. The Commission relied on the fact that the bids submitted by the bidders were identical on several counts and therefore found the appellants guilty and imposed penalty on each of them at 5% of their average turnover. Appellants approached the tribunal.
It was held that the CCI failed to appreciate other essential factors specific to the relevant product and the market and made wrong assumptions on the basis of so-called plus factors and came to an erroneous conclusion of bid rigging. COMPAT not only quashed the penalty imposed by the CCI but also criticized the Commission for imposing penalty under Section 27 of the Competition Act on the total turnover of the companies. COMPAT went on to observe that imposing such penalty amounts to grave illegality and clarified that the Competition Act authorizes penalty to be calculated only on the relevant turnover of the companies. The basis of calculation of penalty under Section 27 has been a long-standing issue of contention between the Commission and the COMPAT. Our second case covers another interesting order passed by the COMPAT, once again questioning the procedure followed by the Competition Commission. The moot issue was whether the Commission is under an obligation to indicate the reasons for disagreement with the findings of the DG and therefore give an opportunity to the opposite parties to file their objections before passing the final order. Here are the facts.
The information was filed by Express Industry Council of India before CCI, alleging that the appellants Jet Airways Ltd, Spice Jet Ltd, Indigo Airways, etc. had informed a cartel to introduce fuel surcharge for transport cargo. The DG investigation found no direct and indirect evidence for existence of any sort of cartelization. But the Commission took a contrary view and held that the appellants had acted in concerted manner in fixing and revising fuel surcharge and imposed penalty. The appellants challenged the impute order on several grounds. One of the principal grounds was that the same was passed in violation of the principle of natural justice.
The tribunal upheld the contention of the appellant that principle of natural justice was violated as the Commission was under an obligation to indicate the reasons for disagreement with the findings of the DG and issue notice to the parties incorporating the reasons of disagreement along with an opportunity to file their objections. This order can have deep ramifications because the Commission under the Competition Act 2002 is not required to give any right of hearing before passing the final order, but the COMPAT has interpreted this requirement into the provisions of Section 26, which can open Pandora box of several other appeals. Let's now move on to the word of IPR. And what could be a better way than to discuss the ongoing standard essential patent litigation between Ericsson and the Indian handset manufacturers. Ericsson, after its latest setback in the Delhi High Court, receives one more jolt again in Delhi High Court. The bone of contention was whether non-production of license agreement by the plaintiff on record before the court, which is vital for deciding an infringement dispute, can be termed as suppression or concealment of material facts. Here are the facts.
Ericsson had filed an infringement suit against Xiaomi Technologies for using chipsets in its mobile handset on which Ericsson holds standard essential patents. It was contended by Xiaomi that those chipsets were being used pursuant to multi-product license agreement entered between the Ericsson and Qualcomm, which allowed purchaser and customers of Qualcomm chipsets to use them freely. It was argued that Ericsson had purposely suppressed these vital information before the court.
The court held that a party seeking an ex parte order has a heightened duty to disclose all the material which was relevant for the purpose of the ex parte injunction sought by it. The court ruled that non-disclosure of the license agreement was a material suppression by Ericsson and therefore its case was dismissed. Who does not listen to FM radio? FM radios and courtroom battle sound strange, isn't it? But this time, two Delhi-based FM radio channels locked horns over a trademark issue. The dispute before the Delhi High Court was regarding the prior use of trademark word Nasha in the name of their respective programs. Shalu gives out the facts.
The plaintiff company is an internet radio channel, Radio Mirchi, which provides music and songs using trademark Pehla Nasha. The defendant is also running an FM radio channel using the trademark Radio Nasha. The plaintiff filed suit against defendant for using the word Nasha, considering itself to be the exclusive owner of this word Nasha, and asked for relief of injunction. The issue tackled by Delhi High Court was whether the person using the word Nasha as a part of its trademark Pehla Nasha can be said to be its exclusive owner when there exist other music suppliers and websites who have already adopted the word Nasha with respect to their music and songs channels.
The High Court found that the playlist of Nepali Nasha and Haroon Ka Nasha in the website of 8tracks.com are existing since the years 2012 and 2013 and of nashamusic.com since 2006. It was observed that these websites have existed prior to adoption by the plaintiff in the year 2014 of the trademark Pehla Nasha. Hence, court denied interim relief against infringement of trademark. That was too much of Nasha, isn't it? Now, we deal with a very important Delhi High Court judgment where the court has elaborated the meaning of the expression Encumbrance within the scope of SARFAESI Act and rules. Issue was whether a nature of leasehold title amounts to an encumbrance within the scope of SARFAESI rules, which should have been duly disclosed in public notice for auction sale of property. Here are the brief facts.
The state of Himachal Pradesh as lessor granted one property on perpetual leasehold rights in favor of lessee. As per the grant, the lessor had the right to recover up to 50% unearned increase if the lesseehold rights were transferred for consideration upon prior permission being granted by the lessor. The lessee company mortgaged the property to SIDBI for a loan sanction. There was default in the return of loan and proceedings started under the SARFAESI Act. It issued public notice for sale of property. The petitioner Midas Electronic Private Limited was the highest bidder who paid the entire consideration. But later on, the petitioner wanted to cancel the sale on ground that the state of Himachal Pradesh had raised a demand on account of outstanding dues payable by the lessee. It was argued that the property was encumbered and it was not disclosed in the notice. The DRT ruled that when a sale was on as-is where-is basis, it was the duty of the bidder to ascertain title to the property. The tribunal also dismissed the appeal. Matter went to the High Court.
The High Court dismissed the petition, holding that when a property is put up for sale on as-is where-is basis, a leasehold title does not amount to an encumbrance and need not be disclosed in public notice for sale. The last case of this episode deals with situation where a debtor company was undergoing winding up and creditor's outstanding amount was not paid. The question before the court was whether a creditor can take the recourse of winding up petition when the amount of claim is genuinely disputed and pending adjudication before the civil court. Let's find out the details.
The petitioner was a creditor of respondent on account of business dealings where material ordered by the respondent was supplied to it on credit basis. Upon non-payment of outstanding dues, petitioner sent a legal notice to the respondent. Respondent replied that they suffered a loss due to non-supply of a specific product ordered, therefore the purchase amount was set off and adjusted with loss suffered. The respondent company was undergoing winding up process. In these circumstances, the petition was filed.
The High Court dismissed the petition and directed the petitioner company to take remedy in accordance with law and not to take recourse under the winding up petition since the matter was pending in a civil court and the contractual amount was disputed. And that's the wrap of this episode of Legal Wrangle on corporate laws. Thank you for watching.